Welcome everybody. It's time to stop the chatting, Katarina and Ludwig, because we're going to start a seminar. So I'm very happy to have Patricia Mindus and Rebecca Stern here, both researchers at the Institute, which makes me even more happy. And actually, Rebecca used to rule over me in the board of the Institute. So that's what academic life is. You change positions. So Patricia is a professor of practical philosophy at Uppsala University, and she wrote her PhD thesis at the at University of Turin in EU studies, citizenship, the debate, the concept, and the European case. And in general, you do research in legal and political theory, theories of citizenship, migration, and institutions. But you also, which you not, I think, the book that I appreciated the most was actually about Axel Hägerström. So I really mind the life and work of Axel Hägerström, which I warmly recommend. Rebecca is a professor of public international law at Uppsala University and wrote her dissertation on 2006 on the child's right to participation, reality or rhetoric. And is also founder of the Network on Migration Law, and you've done a lot of research in migration, asylum, human rights, international versus national law. And you published a lot in that area. And now you're going to talk about juridical time and its role in migration law. The floor is yours.
Thank you very much. So we're very happy to be here and to introduce our new project that recently started. So it's work in progress, we can say. And what we're going to do in this project is to combine expertise that we have from different fields. So from my side, I will contribute with knowledge from citizenship studies, and I'll be working mostly on the notion of citizenship. And my colleague Rebecca has an expertise on international law with a focus on migration law and human rights. So we will try to combine the various expertise in this project. So you will have noticed that in Sweden and elsewhere, migration law has been, over the last few years, in flux. No need to rehearse here the political contextual reasons for why this is so. This is a project that doesn't look so much at these reasons, but at the effects, right? So we're rather interested in understanding the effects of a changed policy landscape, and specifically what it means for legal statuses. So some of the novelties we've seen is time-limited residence permits, revocation of refugee status, stricter naturalization policies, introduction of citizenship revocation or forms of lapse of status. Now, we could think that traditionally stability and long-termism has been very important for legal statuses such as residence and citizenship. But times are changing, and we could say that if you look at the period 2013-2019 in the European Union, laws on nationality were changed over 100 times and at an increasing pace, which in itself is interesting because these used to be laws that were rather stable over time, but now they're no longer is. So what I can say generally about migration and time, no, maybe here, no, no,
no.
Okay.
No, why is this window up rather than this window? Go there.
Stand over here.
Like that, for example.
Okay.
Or you can use that.
Yes, thanks. Wonderful. So migration, I was saying, is just as much a question of movement in space as it concerns time. And I think it's important to notice because a lot of people try to kind of equate migration to a movement in space, but that's really an oversimplification because a person's physical location might be totally irrelevant to determine a person's migration status. So migration can result from all other things, such as a change in personal status, marriage, divorce, childbirth, adoption, right? But also a change in the law. So, for instance, because you introduce a new ground for loss of a status, it can also be due to a change in the territorial validity of the jurisdiction. We all remember Brexit. And it can be due to aspects relating to time. So, by the passage of clock time, say, because you reach the age of 18, or because 5 years or 8 years have passed, or it can be due to other forms of crossing temporal boundaries, such as when you miss a deadline for an application, say. Notice that the UN definition of what a migrant is also time related. So the definition is a person who moves to a country other than his or her usual residence for a period of over 12 months. Now, if you do not consider time in the equation when we discuss migration, then all tourists would be migrants, right? So time is, I think, a key dimension to understand how migration takes place, right? Not only within the not only in relation to territory, but also beyond borders. So it's a key governmental technique. We know that we can use time in order to obtain changes in people's behaviors in a number of ways. Of course, making people wait is an attribute of the powerful. We know this. And we can operate as much through temporal devices as through spatial control. And these uses of time are of interest both to international law and to national law. So we're interested in both of these levels of law. Rebecca, let me hand over to you.
Thank you. Feels a bit like doing a presentation in a classroom, actually. We're standing both here and sort of looking at each other. So thank you so much for giving us the opportunity to present our project. So the project is then called Status and Stability, an examination of the importance of time in Swedish asylum and citizenship law. This is a project funded by the Swedish Research Council for 3 years, and it will run until mid-2027. It's only me and Patricia in the project, so it's a relatively small project. Hopefully there will be others following. We'll see. So the project combines legal theory with public international law, international migration law in particular, and national migration law, as Patricia has just explained. National migration law includes citizenship, or as it also may be called, nationality law. So when we speak about migration law, we also speak about laws regulating citizenship. The overarching aim of the project is to generate knowledge on the significance of time in migration and citizenship law, and also to investigate and analyze the consequences of undermining the stability of an individual's legal status. So we're interested in understanding what time means in this context. How is time used? How is it not used? What weight is according to time? And how is time used as the way of controlling and regulating migration? The hypothesis we're working with is that Sweden, because the focus is Sweden, and I will come back to why that is the case in a little while. The hypothesis is that Sweden is moving away from a traditional regime favoring stability of status towards a regime of temporary statuses. For example, when it comes to asylum no longer necessarily means durable long-term solutions, as has traditionally been the case. And citizenship might not longer be a lifelong link of attachment, because citizenship and the rules of citizenship and when citizenships, for example, can be revoked are also changing. And let's see, that went a bit too fast. So this changing approach may make a country, in this case Sweden, less welcoming and attractive towards long-term territorially present non-nationals. We focus on Sweden, but the idea is that the model we develop for studying these matters will work for studying other countries as well. So this is sort of a pilot, you could say. Now, we received funding relatively recently for this project, but it's been in the making for quite some time. And also the use of time as a tool to control and govern migration is a research topic that has really increasing attention both in law and in migration and citizenship studies. So our project is part of this emerging field, and hopefully we will also contribute to developing the field. That is at least the aim as well. Now, background and context. What migrants of all categories have in common, basically, is that their lawful entry into a country is conditional upon them fulfilling certain requirements. We have no open borders. And these requirements, they differ depending on why the migrant wants to enter a specific country. Is it because they have a need for need international protection? Is it because of family ties? Is it related to work, higher education, whatever it might be? And this in turn, these requirements, the different requirements, that there are such requirements, this is based on the fact that although there is such a thing as a human right to leave your country, a country is not to hold its the inhabitants as prisoners, although there are countries that try to do so. There is no corresponding undisputed right, legal right, to enter into a country and remain there unless you are a national of that country. So you have a right to leave any country, but you can only enter certain countries. And if you are a person without a citizenship, a stateless person, this of course becomes very much a problem, because there is no country in which you have a right to enter. So this lack of a right to entry is linked to the concept of state sovereignty and the fact that states, as a matter of well-established international law, have the right to control the entry, residence and removal of aliens. And this also explains why we have border controls in different shapes and forms. Physical border controls, such as walls, fences, wherever it might be, but also border controls of a more abstract nature. Passport requirements, visa requirements. And it's sometimes said that in a globalized world where borders seem to play a less important role in many ways, migration control remains sort of the last bastion of state sovereignty. It's the way states have to have some kind of control. However, a state is not completely free to decide who gets to enter and remain. There are rules in international law regulating this. Fundamental principles of asylum law, such the principle of non-refoulement, which basically means that a state cannot deport a person to a place where his or her life is at risk, or where she may be at risk of being subjected to torture or similar treatment, prevents a state from deporting a person to such a place. There are no exceptions to that rule. There are also the rights to family and private life can also mean that a person has a right to be granted a citizenship in a particular country. So there are sort of limitations to the rights of the state to decide who resides on the territory. There is a built-in tension between the rights and interests of states and the rights and interests of individuals. This conflict of interest is in part what has put migration high on the political agenda for years, something that increased even more or intensified by the so-called refugee crisis in 2015. It didn't, of course, start there. I mean, migration and control has been on the agenda for decades. But as Patricia mentioned, in the European context, the large influx of mostly Syrian refugees in 2015 really brought these ideas of border control and how to curb migration to a head. And since 2015, the large majority of European states has adopted increasingly restrictive migration and asylum policies, both in response to the 2015 so-called crisis, but also in the years to come. So we see an increase of restrictive policies. And one aspect of this emphasis on control and restrictions is the increased focus on time as a tool to regulate migration. We see a move from permanent residence permits to temporary residence permits. We see increased focus on cessation of status, of revocation of status, revocation of citizenships, both in the Nordics and also both in Europe, in the Nordics, and also in Sweden. So Sweden is part of this sort of general trend. And the changes signal a shift from permanence towards temporariness in status recognition. And we argue that such a trend is a reason for concern, as it may negatively affect, or it does negatively affect, the stability of legal statuses. I will say a few words about legal status in a second, but I would just like to give you a few examples of what we mean by these temporal governance techniques. Migration, as Patricia has already said, is not only to be seen as a movement in space, it's also a movement in time. And Melanie Griffiths coined in 2017 the phrase temporal governance, which refers to diverse manifestations of the rule of time in governing migration. And she describes migration policies as being littered with temporal conditionalities, such as qualifying periods, weights of specific durations, minimum, maximum ages. And she points to a number of different ways in which this can be carried out. Temporal safeguards, notice periods before its deportation. You get sort of a pre-warning before the deportation is to take place. Temporal barriers, timings of applications, deadlines for applications, lengths of stay required in order for you to be able to apply for family reunification, for example. Not only to be reunified with your family, but you have to wait until you can actually apply for such a measure. Temporal punishments, detention is one, return bans is another. Temporal rewards, visas that permit entry and stay for a limited time. Temporal strategies, accelerated processes, delayed processes. Some people can go through a migration process really quickly. For others, it may take years, depending to some extent on whether the states think you're a desirable migrant or not. And there are similarities when it comes to citizenship applications. Patricia, for example, has written about the golden citizenships, which is sort of a fast track to citizenships for those who can pay. So migrants are selected through these different temporal techniques. And you could perhaps say that all states employ some kind of temporal governance regime. It can be generous, it can be restrictive, or it can be something in between. But all do in some way. I should also say that oh, no, I won't. Skip that. By legal status, then, we refer to aggregates of rights and duties attributed to a given person as a subject of law. That is a legal status. And they reflect an individual's position in relation to the nation state. As such, it makes assumptions as to one's allegiance to the state of residence and commitment to the national community.
Sorry, a question of clarification?
Yes.
When you refer to this subject of law, a law of one country or several countries or international law? Is it like the whole gamut?
Good question. Well, legal status would be the relationship to, if it's a legal status in the form of a citizenship, that would be in relation to the nation of which you are a citizen.
Yeah, but
Yeah.
I'm a citizen of Sweden, but I'm still the subject of European Union law.
Mm.
Yes.
And insofar you are a European citizen, you are subjected to the EU jurisdiction, right?
Yes, and
Yeah.
as soon as I travel to another country, like South Africa, I'm subject to that law.
To some extent, yes, you are.
So it's
Yeah.
all of those.
Yeah, but there are different statuses depending on, of course you have a different status depending on where you are, and your commitment to that also then depends on that relationship. And there is this, and that's actually a very good question regarding how you look upon these statuses and the bond they establish. I mean, citizenship is a distinct, privileged bond to a particular state. It gives you rights. It also means obligations, but most of all, it provides you with rights. Immigration status, that is a more sort of a remote relationship. It depends how remote that relationship is. That depends on the status accorded to the migrant or the refugee, for that matter. If it is a more precarious immigration status, it presumes loose ties with the state of residence. More secure immigration statuses, such as a long-term residence permit, for example, assumes a closer bond. So it sort of varies, but the status determines the bond to some extent, or the stability of the bond. A legal status is not immutable. There are conditions for acquisition, there are conditions for loss of a legal status. But to have a secure and established legal status, at least as much as that is possible, matters. Because if a state can continuously modify a status, foreseeability and legal certainty, which are essential aspects of the rule of law, may be reduced. And having an insecure or unstable legal status can also have substantial effects for the possibilities of an individual to make informed life choices. If you don't really know what status you have in a country, and for example, how long you are allowed to remain in a country, how to decide whether to stay or to go. What are your future prospects in that country? Is it a place to start a family? Is it a place to invest in a business? Or would you rather, would you be more successful in requiring a stable legal status elsewhere? So stability of status matters. That is basically the point. And legal statuses, they also contribute to shaping the population over time. And it determines who becomes part of the demos and who has the possibilities of shaping the politics. So who is part of the demos is a constitutionally sensitive matter as well. So what is it that we're going to do in this project? The main research question basically is stability of status eroding in Sweden in asylum and citizenship law? This is then divided into 4 sub-questions. First, we look at how we are to understand references to time in law and the legal meaning of seemingly temporal categories. How is juridical time used in asylum and citizenship law in Sweden? How has this changed under a certain period? Is there a trend toward temporariness? Our hypothesis is that there is, but that also has to be investigated. Which consequences do these changes entail in Sweden's constitutional context, and are the changes justified? So those are the main questions we pose. How are we going to do this, or what more concretely are we going to do? Why have we focused on Sweden? Well, it's an interesting topic of study for several reasons. A common denominator of migration policy made or envisaged in Sweden and elsewhere in later years, as I've already mentioned, is the emphasis on time, normalizing temporary residence permits, abolishing permanent residence permits, cessation, revocation, etc. And Sweden is definitely one of the growing number of countries opting for these more restrictive policies. In Sweden, this policy shift has been quite sudden and quite significant. Sweden has gone from being a country that has been perceived as one of the most generous, especially when it comes to asylum. Generous is a very interesting word in this context, what you mean by generous. I think that Sweden having a generous asylum policy is not an altogether true statement, but that is a different discussion. We've also had among the EU's highest naturalization rates. We've gone from that to a country being argued to be one of the being one of the EU countries with the most restrictive policies, and this has changed relatively fast. The paradigm shift in Sweden regarding the duration of a residence permit which from 2016 and onwards, the main rule is now temporary residence permits. Before that, it used to be permanent residence permits. All of the examples or the decision, all of the proposals being laid out in the 2022 TIDO agreement, which a lot of them focus on limiting times, extending waiting times, etc., etc. All of this point to shift towards temporality. So Sweden is an interesting country to study because of this sudden change of direction, which means the turn towards temporariness easier, we argue, to identify than in many other countries. Why are we looking at asylum and citizenship law? Well, there is this thing, as you all know, called temporary protection, which is laid out, for example, in the EU Temporary Protection Directive, the one applying to the people fleeing from the war in Ukraine. So temporary protection in that sense is reserved for people who are fleeing situations of armed conflict. It applies to situations of so-called mass influx. Asylum, on the other hand, is as such not intended to be permanent, but it has become, in practice, a long-term solution, mostly because people fleeing from armed conflicts tend to stay in the country, in their country of destination, because the armed conflict continues. Or if you flee persecution in a country, unless there is a change of government, there will still be a risk of persecution if you return. So asylum in many ways has become sort of a permanent solution. Citizenship is an irrevocable yet renounceable status, which has also been considered a long-term commitment in many ways. But today citizenship is more difficult to get, easier to lose, and also lesser in value. Before, the passing of time would inevitably lead to a certain outcome, but now time in the context of citizenship is employed differently. The route to naturalization is shortened for some and lengthened for others. And citizenship has in many ways become sort of a policy tool. It is granted to some, not to others, and time is again used as a tool in this context. And this is a trend you can also see in Sweden. There are, for example, the many of the suggestions or proposals in the TIDO agreement, where you have introduced the language test, the civic knowledge tests, a prolongation of the time you have to wait until you can apply for citizenship, etc. So, for these reasons, we focus on asylum law and citizenship law. The time frame is 2001 to 2026. In 2001, the new Swedish Citizenship Act entered into force, so that's where we begin. 2026 is because we are likely to have seen the legal transposition of policy changes announced in the TIDA agreement by then, and also introduction of changes in the citizenship law, which is under revision currently. So that's why this chosen time frame. We will use combined methods from philosophy and ethics in this project. And we will analyze legal materials such as the laws themselves, preparatory works, and case law from the Aliens Appeals Board and the Migration Court of Appeal. So about 60 decisions or judgments. The approximately depends on the fact that we don't really know how many judgments there will be during this time. And there are 4 steps in this project. Theory development, which is currently undergoing, the systematic legal study, an impact study, and the normative inquiry. Yes, Patricia.
Yes, so part of the theory development is to reflect a little bit about this notion of juridical time. Let me also say immediately that the expression juridical time is nothing that you will find in the standard debate. It's my term. And the reason why I'm using this term here instead of, for instance, legal time is that when we discuss migration law, the term legal time might be confused for the duration under which somebody has an authorized stay, right? So I would want to avoid hinting in that direction because that's not what I want to speak about. But instead, juridical time is time and law, so to say. So time theorists have been devising all sorts of different categories in many areas, from music to politics, right? So the historians have la longue durée, the anthropologist will speak about stuck time or frenzied time or stolen time. Sociologists of time will look at acceleration and rhythms in society. In philosophy, there's a whole sub-branch that has developed over the last century concerning time. But this has not really been the case in law, where rather I would say that lawyers seldom use well-developed modalities for representing time and time-related phenomena. And this in itself struck me as something pretty curious, because time it enters every part of law. It enters every part of how we practice and how we think about law. So it functions as a delineator of rights that can be instantiated and terminated in particular moments. It's also an intrinsic part of certain legal concepts like stare decisis, that we stick to precedent, right? Countless are the legal categories that has a temporal dimension. So the list would be retroactivity, precedent, prescription, adjournment, temporary legislation, deadlines, commencement dates, sunset clauses, evidentiary statutes of limitation, preemption, foreclosure, suspension, waiting times, etc., etc. Right? So it's obviously all over the law, right? Now notice also that time is both an object and a tool in law. It's a tool in law insofar as we use people's time in order to obtain certain behavioral effects, to make them do things they wouldn't do, or to making them avoid behaviors that otherwise they would have engaged in. So temporal governance is the strategy to discipline and control people by the means of time. And it has been noticed, there's an increase in scholarship of political science on time, and it has been noticed that in legal context, the control of processes that occur over time can sometimes be just as efficient as the control of bodies. But I was saying it's also an object of time, an object of law, sorry. So time in that sense, you can just imagine, think of calendars, which have always been a fascination for all political reformers, right? From Julius Caesar to the French revolutionaries, who not only shot at the clocks, but also imposed a new calendar, a new time that we, by the way, twist of irony, recall being Anno Domini 1793. Mussolini instituted a fascist era. Hitler had his millennial Reich. We have our daylight saving time. Our meeting is taking place in Central European time. All this is known. But time is also an object of law in a deeper way still. Law redefines the meaning of natural language terms. So that's a fascinating aspect about law, because there's a gatekeeper to legalese, we could say. So in law, we can decide that a business day is less than 24 hours. And for the purposes of EU migration law, for example, a season, in order to qualify as a seasonal worker, is 9 months, right? Time is also, you will have noticed this, one of the most valuable, finite resources of human life. So memento mori, right? We are all here only in transit, right? And of course, The fact that our time is finite, that it cannot be turned back or started over again, matters for justice because not all people have the same quantity or quality of time. People have different ages. So we need to understand how people's time is being valued. Is it fair? Is it appropriate? Are there reasonable grounds for this? And this can be done only if we pay attention to the uses of time. However, what we typically find in law is a situation where time is assumed to be some kind of natural phenomena, unfolding effortlessly at the backdrop of social and political life. Okay, so I'm not sure I know what juridical time is, but I'm starting to become a little bit more certain about what it is not. So I think that for sure it is not the temporal dimension of the world, or so the abstract idea of time that philosophers argue about. So it's not what is relational for Aristotle and absolute for Newton, right? It's not that kind of thing. Nor is it the fundamental quantity of quantifiable aspects of the world that physics measures. So what we're going to call clock time, right? It's not that either. And the reason for this is that in law you find all sorts of discretional durations. You can think of expressions such as soon as possible, forthright, immediately, within reasonable time, without delay. And of course, it's not the fourth dimensional continuum that is represented by the mathematical model of space-time either, right? It's something else. But it's not the durée, the Bergsonian idea of personal and lived time, that we sometimes have the temporal consciousness that time seems to be very slow or to speed up. I mean, this kind of perception of time matters for how we appreciate time in law, but it's not itself juridical time, right? It's also the fact that is important, I think, is that juridical time is always someone's time. But at the same time, yes, we do not always know whose time is being determined. And this is due to the fact that law is typically expressed with having the characters of abstractness and generality. So it's expressed for all categories of subjects, right? And therefore, it's not always clear whose time actually is being impinged on. I don't think it's reducible to simple numbers of references to so-called durational clock time. So a week, a day, a month, etc. It's not just the number of these references, even though these references may matter, right? And the reason why I don't think so is that the use of clock time that is done in law differs from clock time, right? So that's why a working day can be any day of the week except Saturday and Sunday, right? And I think particularly interesting is the use of labors such as temporary stay, permanent residence. What do they mean, right? It's, as a matter of fact, not established in legal science how we are to understand these terms, right? So an important thing I want you to notice is that juridical time is marked by malleability, right? Contrarily to clock time, juridical time can stop, it can reverse, it can start over, we can rewrite history. Right? Juridical time also responds to social expectations in ways that clock time clearly doesn't. So for instance, if you are a student on Erasmus Day in another European country, you will discover that your stay is temporary, not because of your intentions, but because the state has an expectation of the fact that you will leave once you have finished your studies, right? Okay. In the fascinating literature over time and law and politics and time, one book that really stands out, I think, is Elizabeth Cohen's book on the political value of time. Elizabeth Cohen will be with us tomorrow for the workshop that we're organizing. But it also struck me that that theory is very much a theory about how time is used, right? So it's really a theory about the function, right? Not about the nature. And as a function, she thinks that time is used as a technique of transaction. It's a type of measure, she says. She says that it's a unit of commensuration. So people having very different views and ideas about something. For instance, how long the time a person should spend in prison. People having very different opinions about why that person should or should not go to prison can, however, end up on agreeing on a number, right? So in that sense, it allows some form of commensuration, right? It's a very interesting theory, and she also says that time could be thought of as a unit of political currency, which struck me because this metaphor of currency that has been employed by Scandinavian legal realists such as Olivekrona to point out that there's a conventionality dimension here that needs to be brought to the light. So I will try to delve into this metaphor and figure out a little bit more how we can use it. So my take here is that the nature of juridical time basically evades jurists. Some do say that it's an abstraction where temporal logics developed for the real world may not be fully adequate for the law. Fine. There's some abstractness to it. I'm willing to concede that, but it's not really useful for us. We can't really work with a theory like this. Others think that it's a social construct given meaning and form through social conventions that are themselves highly context dependent. Also there, fine, it might be a social construction. It's also a social constructor, right? But it's not really useful for us to work with such a theory because it's simply too vague. Nobody seriously thinks that a date is something given by nature, right? So my hypothesis is rather that what we're dealing with is an institutional fact, and the constitutive rules of this set of institutional facts can have different levels of clarity. And that's what we should be focusing on, right? And we need to spell this out. So generally we could say that legal thinking concerns what philosophers would or social ontologists would call institutional facts, where a function is attributed to something that doesn't have this function in virtue of its empirical properties. So you can imagine, say, a rule in certain contexts, maybe the fact that something counts as a point in a board game. Right? It's not the nature of the thing itself, of course, that will make it a point in a board game. Often in board games, by the way, we do not need things at all to be counting the points. We can do that perfectly as abstract points, right? So what makes the point such is rather that there is a constitutive rule that says that in this rule, the point shall play this role. Right? And I think that's a useful way to think about also juridical time. Notice also that status that we were speaking about before is also a little bit like a point in a board game, right? It's something you can win, something you can lose, something that might be worth having, even though in itself, of course, it is not an empirical object, right? So philosophers say that we exercise our deontic powers in creating and shaping these various forms of statuses. So I think that perhaps juridical time is best viewed as an institutional fact, but not a generic form of social construction or a simple abstraction. But it's more akin to money or to social board games than it is to clock time or to mobility, say. Because there's something in law, these constitutive rules, right, that make time, clock time or human time relevant. And it is that legal relevance that we need to track. So I tried to figure out what kind of object could qualify for juridical time. And some people would think that the times of the legal system, that's something to be looking at, right? So the mechanism of development that explains the evolution, continuity, and change of legal systems. You can think of the theory of Niklas Luhmann or Gunther Teubner, right? And I think that's not really what I'm after here, because these are theories about how the system of law changes as it is influenced by factors external to it. Rather, I'm interested in stuff like the laws of time. So these are the rules and the conventions that determine how we organize our clock time, calendars, how we set our clocks. You can think of the rules that regulated the transition from the Julian to the Gregorian calendar in early modernity, or the emergence of standard railway time in the 19th century US, the global adoption of the Greenwich Mean Time, the century-long struggle over daylight saving time, or the current controversy concerning leap seconds. So that's an object of the juridical time I'm speaking about. And another one, and this is a really big chunk, are process and procedure related rules and conventions that set the practical implications for how durational time is employed in legal institutional settings. Waiting periods, schedules, recurring deadlines, statutes of limitation, budgeting cycles, right? This is undoubtedly a very broad category of objects, but it's different from the previous one, right? And it's different from this later one, what I call times in law. These are the temporal conditions under which a norm gains validity. So Hans Kelsen uses this complicated way of saying this. He calls it the temporal sphere of validity of the law. Okay, so what is that? I'll give you an example. Transitional provisions or transitional regulations. Sometimes when we amend law or when we change law, a law or a whole legal system, right? When that happens, we have to decide for how long and under which circumstances the previously applicable law will be applied, right? And the continued validity of the previous law is important to enable trust of the citizens and to ensure that legal entities are able to adjust their behavior to the applicable law. Now, the theory of juridical time I hope to develop will be valid for the three latter categories here, but not for the first category that I would exclude. I don't think it really has to do with it. So an important thing to notice is that legal certainty, of course, it requires that we have some transparent, consistent legal enforcement, but it also requires that we're clear on the grounds and procedure for the operability of a legal norm in time. And that refers to the times in law, right? So typically we would say that law has three types of operations in time. It can be prospective, retroactive, or ultraactive, right? So when it's prospective, it means that you make the rule is done in time 1 and it is being applied in time 2, right? That is the tempus regit actum principle from Roman law. We typically think of law as prospective in that way, but there's numerous exceptions. So in retroactivity, a norm is applicable in T1, although it only became a member of the system in T2. And in ultraactivity, it works the other way around. That is that it will be applicable in T2, although it is no longer a member of the system in T1. These two dimensions have...
Just quickly give some concrete examples of those three.
Yes, so often prospective is the normal way of working of the law. So I think that doesn't need an illustration. But retroactivity is typically the case where you introduce a norm, but you make it the case that it will apply to behaviors that had occurred before the entry into validity of the norm, right? Now, normally, we do not like retroactivity, and in certain areas of law, retroactivity is utterly banned. Criminal law is one of these cases. But we can apply retroactivity when it's favorable to the person, right? So there are a number of instances in which it might be perfectly reasonable to apply retroactivity. Ultraactivity is the same thing. There are cases in which it might be sensible to apply the law in ways we normally wouldn't, because it might make sense for the person involved to have a more lenient condition, right? So sometimes these are employed as exceptions to the general rule of the prospective application in law. You also have something called retrospectivity, and that's not my term, that's Helen Xantakis' term. And that's a provision that applies only to facts that have already taken place and may not occur again. In order for this to happen, the facts need themselves to be very clearly described. So you need to know exactly which persons and exactly which action happened. So that could be the case if you say, this rule only applies to people who have, graduated from Stockholm University in this discipline during spring term 2025. Then that is a controllable group. And once spring term is over, that group cannot be enlarged, right? And then you can use norm in retrospective ways this way. Okay, but all this is just to point out that the legislative techniques really matter here for understanding time. And on that, I think I'm going to hand over to Rebecca.
I can just say that when presenting our project to lawyers, legal scholars, there we are. When presenting this project to lawyers and speaking about juridical time, the majority does not understand what we're talking about. Because, and I'm saying this because time is such a key aspect of law, but it's also an aspect that is taken for granted in many ways. We use these terms, waiting times, accelerated procedures, etc., in a number of legal fields, but it's rather rare, actually, that you try to understand what they actually mean. So developing a theory on juridical time is, of course, not only applicable in the migration context. That's the example we use, but it will be applicable on all fields of law. And I also think that it is that's also why it's become so interesting for a lot of legal scholars and also practicing lawyers to try and think about what it means, because this tool, when you start thinking about what time means, the importance of this tool becomes evident, and it also becomes evident that you need to understand what it means. So, what are we going to do? Just to sum this up. What we aim to do is to contribute then to the growing literature on time, temporality and migration law. As I said, this is a growing research field, both with the theory development but also a model on how to study the temporal turn in migration law on the national level, the Swedish example, so to speak. Why is this novel? Well, we not only investigate the effects of a temporal governance regime, we discuss its causes, its justifications, based on the theory developed by Patricia. So far, we've organized 2 international conferences on this theme, one in Amsterdam in 2023, one in Uppsala in 2024. We are currently editing a special issue on time and temporalities in European migration law. In the journal European Public Law, we are editing an forthcoming research handbook on time and temporalities in migration law, and we will also hopefully produce a number of journal articles. But I would say that it is the, being a legal scholar myself, I would say that it is the development of the theory that is the key, hopefully the key outcome of this project, because it will influence, it has the potential of being important for a number of fields of law. Yes. So now we're switching again.
Yes. So summing up, what we've been saying basically that we're interested in changing in asylum and citizenship law in Sweden, how they relate to time. And that legal statuses, of course, are not immutable. They change over time, which is perfectly legitimate in itself. But we need to understand better how the regulation of these conditions impact on the stability for the status holder, and in particular in relation to time. And the reason is that an overview of how a state employs references to time and temporal categories in these areas of law has not yet been made, and it's important in order to discuss temporariness in informed ways. Underneath, there is a normative question, and that is the question that we would also like to discuss with you. That is, what role, if any, what destabilized legal statuses play in membership practices. Thank you.
Thank you.
Thank you very much for the thought-provoking presentation of your project. And I gather this is like the harbinger of a greater project. It's called Time in Law.
Hopefully,
10
yeah.
years of work. And maybe time as a
program,
power technique,
yeah.
which is also came up and you touched on. So fascinating. And I think it shows how interdisciplinarity makes things greater. We have question time, as usual.
Take the research question back.
Yes.
Well, we have question time, and as
I'm
usual,
getting
we
there.
have an audience online. You use the chat to write your questions, and please tell us your background, because we like to feed questions from different fields. And we allow for hand, which is a new question, and fingers, which are follow-up questions. So use that, and in the chat, you just write follow-up to the person you're following up. And not very unsurprisingly, we have the first question from somebody who has a very keen interest in law, Ludwig Beckman.
Thank you for an excellent presentation. It was really enjoyable. So I want to go back to the research question, actually, and I was wondering a bit about how time is related to stability of legal status. I mean, and also have a question about what you mean by stability of legal status. So it seems like temporal strategies that you identify here surely can be used as a way of undermining the stability of legal status. That's quite clear from your presentation. But it is not clear to me that all ways in which stability of legal status are undermined are necessarily time-related. So revocation of citizenship, for instance, you mentioned that several times. For me, it wasn't clear in what sense that is a time-related strategy. If, for instance, as in the proposal now given by the government in the latest commission in 2 months ago, according to which citizenship can be revoked for a person that commits certain crime. I mean, that doesn't seem sound to me as a kind of time-related strategy at all. So it seems like there would be ways in which your focus on time sort of is not capturing all possible ways in which stability of legal status can be undermined. And the second question then is related to this, because it's stability of legal status. I mean, I'm not sure about first what you mean by stability here. I mean, stability can have this kind of durational aspect to it. I mean, it's more stable if it just lasts longer. But then you mentioned it's security. But I mean, just because it lasts longer doesn't mean that it's secure. I mean, it can be just an arbitrary consequence of the fact that the government doesn't decide to revoke your permanent residence permit, for instance. On the other hand, you can have a very secure status in a short time. You can be very legally secure that I will have the right to stay here for 3 months. They cannot revoke that. So you can have a secure but short time. You can have an insecure but long time. And also, I wonder if it's necessarily a good thing to have stability of legal status. Doesn't it depend on what kind of legal status you have? I mean, so if you're a refugee, well, that's a status, but is it good to have that status for a long time, or have it stably? I'm not sure about that. Okay. So yeah, a couple of questions. Thanks.
Yeah, so I think that stability is indeed an under-scrutinized notion, and you're right in pointing that out. So there is a dimension of stability that has to do with foreseeability in law, right? And that is the direction which we're taking. Now, it is the case that, for instance, citizenship revocation at a first instance does not seem to have to do very much with time. But for instance, the way lapse of citizenship is practiced or has been practiced until now in Sweden, it would be applied at the age of 22 for citizens who are born abroad and resident abroad, for instance. So there's clearly a time dimension to how the lapse of status kicks in. And it's also the case, for instance, when we discuss criminal activity in relationship to loss of citizenship, that whether and how the criminal activity takes place in time can matter. So since when have you had no criminal activity? Since ever? Right? And that can matter for whether that loss will kick in or not, right? So there is a temporal dimension that shouldn't be undervalued. But I understand that we need to think more carefully about stability, because clearly we are assuming a little bit here that it is stable allows foreseeability, and the fact that it allows foreseeability allows also the individual to understand how to operate, right? The fact that you have a changing, an unstable status means that it becomes harder for you to kind of calculate what you ought to do or no, you shouldn't do, right? So it becomes harder to plan your life. And the difficulty in planning your life or making informed decisions about your life is itself a problem. And the reason why that is a problem has to do with the memento mori, the human life that passes as you're thinking about what would be smart to do about your life, right? So there's something about the stability that is temporarily sensitive in that sense. Perhaps you would want to add something about the
No, I think
security.
that, yeah.
Could I just clarification? Stability you're talking about is that the law is not changing.
Well, the law can change in many ways, but that it doesn't change in such a way that your legal status change, with the effect that you do not know whether you can stay, you should go, whether you can, right?
Yeah, maybe it seems that whether you can know or not is a separate question from how things are changing. And some things can be very predictable. That they will change.
Yes. And if they are sufficiently predictable,
I mean, some things even in the law you have, this applies to people to that age, conscription, for example. So then it's already, all these changes are already in law, so the law doesn't change. But there is a predictability that you will not be a subject to that law when you're over the age of 28 or something.
Indeed.
I think perhaps if I understand you correctly, I think perhaps the example of the previous criminal activities now introduced as a possible grounds for revoking citizenship might be relevant here. If you would know that if I committed a crime 10 years ago, then my citizenship can now be revoked on those grounds, then you would know, right? But if it is a question of previous criminal activities and the previous is decided on a case-by-case basis. It's decided through case law. What kind of criminal activity is if you committed a murder 10 years ago, then you're out. If it was petty theft, then it's fine. So those kinds of aspects as well might contribute to the instability. We don't. The temporal aspect means that it's sort of more fluid. And I think that's one of the things that affect the stability. Yeah.
Eva?
Thank you. So I was curious if you could give, maybe Gustav hinted at this before, but I was wondering what will be the practical use of this juridical time? I was curious if you can give more example, because I was thinking, why not use clock time to study this? What do we miss by doing that? And wouldn't it be interesting to compare or see the discrepancy between juridical time and clock time? And I guess this goes back to what is the fundamental normative problem? And maybe this relates to Ludwig's point, but is it the stability of legal status? Or is it that Sweden has gone from the generous to restrictive? I mean, that we could see as depending on our views, of course, as the fundamental problem. Yeah, I was wondering if you could say something more about that.
Yes, so there's two problems ongoing at the same time. One problem concerns understanding how time in law works, right? And another one concerns the particular case of Sweden, what has happened. And should we say then that what we're witnessing is a turn to temporariness, as it has been called in the literature? And if it is a turn to temporariness, how ought we evaluate this, right, from a normative standpoint? But let me start with the first. Why should we care about this time in law business? Well, why couldn't we just relate on clock time, right? So, for instance, Klaus Göst just published this big Oxford handbook on time and politics, right, in which the references to clock time are all over the place. But at the same time, he pays due attention to other forms like synchronization, sequencing. All these forms matter to how decisions are being taken. Anyone who has ever drafted an agenda for a meeting has met with that difficulty, right? So it's not just a question of clock time, but also sequencing, right? That matters very much for outcome. Now, the way we currently debate or discuss time and law is a little bit clumsy. And I think that hopefully, if I can make some progress there, and this argument about juridical time being an institutional fact is geared towards pointing us in the direction of looking at what would be the constitutive rules according to which your clock time counts or doesn't. Because it's all a question about when does it become legally relevant, right? Now, we all understand that the human time will continue ticking in the background. And by the way, something that is specific about human time is that we cannot know beforehand how much time we're given, right? So lactis, one of the 3 Greek moiras, the apportioner can give you an apportionate a piece of life longer or shorter, and no one knows, right? So we're all playing a game of ignorance concerning the length of the time of each individual, right? And I think that if we can understand the constitutive rules according to which clock time, durational time becomes relevant, and also the constitutive rules that allow us to say when discretional measures of time, like as soon as possible, within reasonable time, without too much delay, right? What does that mean? And what is the constitutive rule that enables us to say that this is what it means, right? If we can have a greater focus on that, it becomes an object of inquiry and of a more strict scientific kind than not what it currently is, more a debate about all sorts of random things, time-related.
Happy with that, Eva? Then I follow up. One way of understanding Eva's question is to say that, for example, sequencing can't that just be defined in terms of clock time? And secondly, follow up, in the law, aren't you pushed to do that sooner or later, even when it comes in due time and all those things, well taken, kind of very fussy concept? But are they not in the end, as the law works itself out, you're going to be pushed to have some kind of use, some kind of clock time? Number of days, for example.
I'm not saying that there is no reference to clock time in law. There is, of course. But the reference to clock time is not equally relevant for all and in the same way, right? So it matters to understand for whom that clock time will count, right? And the same for sequencing. It looks as if when it says as soon as possible, well, this is something that will occur immediately. But maybe in the ecology of the rules, it might be the case that there's some other norm that will apply retroactively in such a way that as soon as possible will be put on the shelf for God knows how long. So the complexity of the matter is such that greater attention to detail, I think, would be good.
I can just add a concrete example when it comes to the phrase as soon as possible. In another research project of mine, we asked the migration agency to provide us with data concerning asylum decisions. Huge chunk of data. We asked for 75,000 and ended up with, after 2 years, we got 590,000. So that's a big project, and it involves law and AI. But the interesting part here is that the migration agency is a government authority, and requests are to be responded to as soon as possible and handled effectively. It was a relatively simple request. I want the material, I want this data from these years, I want this chunk. Do not do any selection, etc. Just, the data as such. The as soon as possible turned out to be 2 years. It was an interpretation from the part of the Migration Board. They were discussions, but you would never interpret as soon as possible as actually being to the length of 2 years. Because had we known that, we would have made the request in a different way.
I think that's the case in point. In the end, they're forced to do an interpretation.
Yes.
It is clock time.
Yeah, but
Of
the
course,
interpretation...
it's not predictable, which
Yeah.
is another problem, that
Yeah.
you don't know how it works.
But I think the interpretation also, the instability is part of the instability is part of the problem, because saying that it would be 2 years, if we had saying that in advance, that would of course not been as soon as possible. It turned out to be that, but the insecurity creates the problem, I think.
I use that power technique myself. Are you following up or a new question?
It's sort of both, I think. I can't make
You have to decide.
a determination. Let's call it a new question.
Are you sure? I think it's a follow-up. So, microphone.
I guess in some way it might be a follow-up. I had trouble understanding, maybe like you do, what juridical time is. And I think when we talk about, objective time or personal time, sometimes philosophers say subjective time, our sense of time. I get a sense that there's a thing there. And, we can ask questions about it, like, does it have a direction and so forth? And we can give examples where subjective time comes apart from, some other clock measured time or whatever. But when it comes to juridical time, I just had a difficulty seeing that whether there was this thing, right, that we call juridical time. And when you gave examples, they were often examples about what people say, what terms they use. And the terms do have, temporal to temporary, permanent residence, so have something to do with time. And I wonder if, maybe the problem that I'm having is when you ask what is juridical time, there's this presupposition that there's something there that we're talking about. Whereas we could instead ask, what do judges or legislative bodies mean when they use these terms, or how do they make certain decisions? And then the question shifts to the activities of people and what they mean for other people and so forth. And we no longer have to assume that there's a thing, like that flows or what, whatever that we then have to theorize about. And I'm wondering what you think about that. Do you sort of share that suspicion? I mean, maybe not.
That's a very good point. So on the one hand, one could do the epistemological choice of saying, well, it's just the set of words, right? And we can do a semantic analysis and follow that kind of line of reasoning. And that's a valuable activity in itself, right, to be discovering. The reason why I suspect, but I might be wrong, I'm willing to concede that the ontological, social ontological take on the problem is useful, is that it enables us to show that what this juridical time really boils down to is a set of rules and conventions, right? So it allows us to show the conventionality of the matter, right? That, of course, when we discuss the laws of time, we all understand that there's conventionality in the calendar, right? But when we discuss other matters, such as, for instance, the age of maturity, which is a very strange concept because maturity is clearly a process, but the age of maturity occurs just once, right? Perhaps this way of phrasing it in terms of institutional fact can be helpful in order to reflect on these matters. But again, I'm just at the start of this, and as usual, I'm always happy to change my mind.
The change, if you do change your mind, it might not be a substantial change. It could be something as simple as how you phrase the question. So instead of a what is it question, or maybe it could still be a what is it question, you could think, I'm trying to identify a set of conventions, and say something about that.
So would you rephrase the question as, is there something called juridical time? And if so, what is it?
I don't know. I haven't gotten that far.
I thought we could fast track.
Yeah.
Thank you very much for the talk. I found it very interesting. So I'm not a legal scholar, I'm a philosopher, so the question might be a little bit too broad. But I hope you can maybe like help understand maybe some of the other questions. There might be some connections with them as well. So I particularly like the list of different time objects that you presented. I thought that was very neat. So I was wondering if there might be different kinds of normative value that each of these different objects of time in law might have, and that go beyond, or these values go beyond their value in terms of legal normativity, whether there might be some that is not just like the legal value, which, if I understood correctly, the legal value is central to your project, but perhaps not the only interesting normative dimension of legal time that we want, right? So something that sort of like connects more with the value of time for people, right? I think that connects to the question that Tim posted before, and not just like for the functionality of the law itself, like the well-functioning of the law. So I'm thinking, for example, about the category of object that you called laws of time. I think you said that it had to do with how we set calendars, for example, but also the example you referred to at some point about seasonal workers permits that define seasons as like being 9 months, right? So, for example, while some laws of time might score very high in terms of legal normativity, they might serve the legal purpose very well. There might be like ways of legally organizing or categorizing time or periods of time that, in addition to being good for the legal, in terms of like legal normativity, they are perhaps more aligned or much better, say, natural times or biological functioning or human needs, and so on. You also talked about this being important, like temporality being important for making important human decisions, like getting married or starting a company. So I was just wondering if you could speculate a little bit more about additional values that the different objects that you presented there might incorporate beyond legal normativity, and if there are values that are normatively significant that perhaps are missing in those ways of conceptualizing time that are very good legally, but might not be good in other normative domains. I don't know if that makes sense. Long question.
Yes, but I think you're right, because one way of understanding what the legal normativity could be of these sets of objects could be that they're clear, right? And to one extent, we could say, well, calendars, that's a good example of something that's pretty clear. In Sweden, there's a law from 1930 that determines lagstadgad, right? You can have a look at when it says 3 weeks before handing in, a document to a court. How do we count these 3 weeks? That is usually clear when it comes to process, right? So it scores high on clarity. Whether it is useful for empowering a good flourishing way for humans to use their human time, that is totally a different question, right? And it's clear that some of these norms and conventions are geared towards allowing social synchronization. So just to recall this, that when it was discussed to introduce the time zones, it was also discussed the possibility of having one universal time, with the effects, of course, that in some parts of the world, children would go to school in the middle of the night and things like that. And that was precisely the reason why it was abandoned. It would have been clear, but it was just unpurposeful for human existence, right? And I had this idea at the start that the laws of time, they have a clearer constitutive rule behind them. Whereas, for instance, when it comes to attributing relevance in the operativity of law, so retroactivity, ultraactivity, prospectivity, then it's not really clear, right? I had that intuition at a certain point, but I think it's wrong, and I'll give you one example. So when the Julian calendar was introduced, and Julius Caesar had this idea of having 365 days, it was a much more rational system that the one had been previously in place, and he had to add this bissextile year and a day extra there in February, which occurred on the 24th of February, but never mind. when he did that, he proclaimed this, you know, in Rome, and he was then pontifex when he does this. He proclaims this and says every 4th year, right? And that should be clear enough. Every 4th year you have to add this day on the 24th. No, because the Romans had an inclusive count. So they understood 4 years to be 3. And we can still find this inclusive count, for instance, among Christians who say that, that Christ resurrected on the 3rd day. What do you mean the 3rd day? Friday, Saturday, Sunday. How do you count? Because that's the Roman inclusive way of counting, right? And precisely what happened was that when Julius Caesar introduced his calendar, all his subjects disobeyed, right? And we had to wait for Augustus to introduce another year. So not even what looks clear is clear, right?
Happy with that? Then join me in thanking for this exciting project. We're looking forward to the results in the coming years. Thank you so much. We have some talks coming up. Christina Garsten on March 26, Futures by Proxy, Anticipatory Governance Amongst Policy Professionals. And Christina is a professor of social anthropology, but also the director of SCAS. April 2nd, Emily Jones, Afterlives, Edmund Burke, Benjamin Disraeli, and the Invention of Modern Conservatism. And then we have, not the least, Eva Ehrman. The title is going to be announced. Are you going to announce it now? No. Very good. Thank you very much.